हेलो स्टूडेंट्स, कैसे हो आप सब लोग। वेलकम टू द नेक्स्ट सेशन of the company law. Okay, we have studied the public offer in the last session, if you remember. So we will take it further and we'll try to complete chapter 3 of the Companies Act 2013. So in the last session we have discussed the provisions related to the public offer, how a company can go to the public and raise the funds. Now there is one important document we studied, that is prospectus. So when a company is going to the public, the prospectus has to be issued. We are going to talk about the next part of chapter number 3, or you can say part B of the chapter number 3. The today's topic name is private placement. Private placement. So one section has been given for this particular topic, private placement, section number 42. At the same time, we will have to study the rule 14 of companies prospectus and allotment of security rules, okay, and rule 14 of companies prospectus and allotment of securities rules 2014. Okay, so as we all know, rules, these are the corresponding rules, and a lot of flexibility has been given to the lawmakers, or you can say the subdelegated authorities like Ministry of Corporate Affairs. It may come up with various rules and frame the provisions. Now let's talk about the private placement. Unlike what we have studied under the public offer can be made to public at large, but not always. Okay, company goes to the public. Company wants to raise funds from its near relatives, you can say near friends, or the select group of persons which are well known to the company. So now in that case, can't a company go to the select group of person? So that is the reason the provision has been given under section 42 of the Companies Act, where a company can go to the select group of persons and raise the capital. So here we are going to stick ourselves to the select group of persons and not to the public at large. So company is not going to go to the public at large. So private placement is basically a kind of invitation made to the people who are selected group of persons. So can we write down the definition? So private placement means any offer of securities or invitation to subscribe securities to select group of persons. Okay, to select group of persons. So which are the important ingredients in this particular definition? As you can see, it is nothing but the offer of securities or invitation to subscribe securities. To whom? It is made to the select group of person. It is not made to the public at large. So these are the important points relating to the private placement, and it is not done through issuance of prospectus, like we have studied under the public offer. So before we'll move further and understand the provisions relating to the private placement, let's first focus on the very landmark case in India relating to the Sahara Group case. Because somewhere, okay, that case is having a kind of connection with this concept private placement. So let's try to understand Sahara Group case. Okay, what happened in this particular case law? Now, under Sahara Group, there were two entities which wanted to issue the securities, various securities to public. So now Sahara Group had come up with some optionally fully convertible debentures which these particular companies wanted to issue to the public at large. Okay, so first, which were those two entities? It was Sahara India Real Estate Corporation Limited. So there were two entities under this particular group. First one was Sahara India Real Estate Corporation Limited, and second was Sahara Housing Investment Corporation Limited. Okay, so these were the two entities which wanted, these were the unlisted companies. These were unlisted companies, and they came up with the offer to issue optionally fully convertible debentures. So which type of debentures these companies wanted to issue? Optionally fully convertible debentures. So we can say that OFCD. Okay, OFCD, in the short form we can say that OFCD. So these companies wanted to issue optionally fully convertible debentures to public at large. Now most of the public, okay, who wanted to purchase these kind of securities were from the lower strata. So like artisans, you can say laborers, workers, like that. Okay, so when a company wants to raise the capital, company can do it through various type of security, and this was what type of security. When the company issued this security, that time the Erstwhile Companies Act 1956 was applicable, and where one of the provision was saying that okay, shares cannot be issued to the more than 50 persons. So that was one of the provision in the 1956 Act. So let's focus now to the 2013 one. So these securities these companies wanted to issue, and these securities company issued, okay, to almost 2.3 million population. So we can say these companies issued OFCDs to 2.3 crores of population, or you can say people. Crores investors. Now this is a huge number. Okay, so this is a kind of suspicious activity. How come companies, okay, can issue OFCDs to 2.3 crores of, okay, investors? Now under this, okay, now SEBI objected to these particular securities. SEBI objected to the such type of issuance of securities, and SEBI intervened into the matter and said that this particular such type of issue of securities will come under the jurisdiction of SEBI, and there was no particular prior approval taken by the SEBI or no particular compliances were complied with while issuing such type of securities by the Sahara Group companies. That was the objection made by the SEBI. Now on that particular objection, Sahara Group said that before issuance of securities, they had issued the red herring prospectus to the ROC. And that is the reason, okay, these are the unlisted public companies which come outside the purview of the jurisdiction of the SEBI. And that's the reason the such type of these companies are not required, okay, to take prior approval before issuing such type of securities. SEBI's stand was, when the securities are issued to more than 50 persons, it should be considered as a public offer, and all the provisions relating to the public offer of that time should be made applicable to such type of issue. But in this case, the Sahara Group, okay, had not gone to the SEBI and it particular issue 2.3 crores, okay, investors. This issue was very huge. It was around, so these companies raised rupees 24,000 crores. It's a very huge amount. These companies raised 24,000 crores by issuance of these particular securities to 2.3 crores of investors. And that is the reason SEBI intervened in this particular matter. Now, what was the stand of the SEBI? That it should be considered as a public offer, and SEBI ordered. Okay, so SEBI went against the Sahara Group, and SEBI ordered that these 24,000 crores of rupees should be repaid to the investor, because this is a kind of clear-cut violation, contravention made by these two Sahara Group companies. On which the Sahara Group stand was, no, we are not going to repay back this particular amount, and this matter went up to Supreme Court. Of course, it went to the appellate court, and then it went to the Supreme Court. So when the matter came before the Supreme Court, okay, around in the year 2013. Now, before Supreme Court also, SEBI stand was similar, that it should be considered as a public offer, and Sahara Group should repay back that particular money. After verifying scrutinization of all the facts, material facts before the Honorable Supreme Court, so Honorable Supreme Court gave the order, okay, and against the Sahara Group, and even the Supreme Court was of the same opinion. Whatever order was passed by the SEBI, for that matter, SEBI is Securities Exchange Board of India, to repay back the money, the similar kind of order was given to the Sahara Group, that the 24,000 crores of rupees should be paid in 3 installments. Now, there was a big question before the Sahara Group. It's a very huge amount, and it was not only about the principal money. The order was given for the interest as well. Now, out of which somewhere around 500 to 700 crores, okay, so 500 to 600 crores were deposited with the SEBI by Sahara Group. And surprisingly, after few months, okay, or few days, Sahara Group published an advertisement stating that we have repaid to all the investors entire money. Now that was the biggest question before the Supreme Court again. So Sahara Group, okay, made that particular statement before the Supreme Court that we had repaid the money to all the investors. And it was a kind of thing like the money was taken in cash in most of the cases, and again it was repaid in cash. And then the Supreme Court asked to provide the documentary evidences for after making the repayment to the investors, and the Supreme Court ordered to submit those documentary evidences to the SEBI for that particular matter, on which it was a very surprising fact. Almost more than 100 trucks or lorries, you can say, were sent to SEBI's office with all the documentation, okay, of evidences like vouchers and everything, the amount repayment receipts, everything, and it was sent to the SEBI's office. Now there were various suspicious activities going on in this particular case, and further, okay, in this particular case, Subrata Sahara, who was the managing director and whole and soul of the Sahara Group, was arrested somewhere in the year 2014 for uh, for delaying the things and for divulging this matter, or you can say diverting this particular matter to the to somewhere else. And it was ordered again, okay, that payment should be made, because one cannot just say that the entire payment was made in the cash and all that. So this matter went on a long time, but somewhere this case is having some kind of connection with our today's topic, that is private placement. Why this private placement provision has been incorporated in 2013 Act under section 42. So let's try to understand. So after this particular incident, when the even our Companies Act 2013 was in the phase of drafting, was in drafting phase, and it was in the phase of finalization and implementation, this particular provision was added, okay, so that no person, no company in future can take such type of stand. And now the provisions are very clear. It is very unlikely now such kind of incidents may happen. So after understanding section 42 private placement provisions, you will come to know how now these cases we cannot witness such type of cases in future. So let's try to understand private placement. So important points which we need to keep in mind. Important points relating to private placement. Okay, private placement relating points, so we'll try to understand one by one. What is private placement? Okay, so as we have studied, private placement is a kind of offer of securities which should be made to the select group of person. So first, okay, first point should be, it should be made, the offer of private placement should be made to selected group of persons. Okay, to selected group of person. Company should issue private placement, I'm using the short form, offer later. We will discuss. Private placement offer should not be made to more than 200 persons. As per law it is 50, but as per rules it has been modified to 200 persons. Private placement excludes qualified institutional buyers, and and employees of company under ESOP. We'll talk about this under ESOP. The value of such offer per person shall be with an investment size of minimum 20,000 rupees. So it should be made for the minimum 20,000 rupees. No company shall release any public advertisement or utilize any media to inform public about the offer. Point. There are so many points because one needs to understand this private placement in a better way. Offer shall be approved by shareholders by passing special resolution. By passing special resolution. The offeree shall receive the offeree shall receive the offer by name and complete record, and that a complete record shall be kept by company. person other than a person address shall be allowed to apply as I told you there are more points. The subscription money for private placement offer should be paid either by check or DD and not by cash. Monies received shall be kept in separate bank account in a scheduled bank. दूसरे अकाउंट में रखना पड़ेगा. The company can't utilize monies received unless allotment is made. Within 60 days. Return of allotment should be filed within 15 days with ROC. Repayment of application money in case of default make allotment. Okay, to make allotment. So these are some of the important points one needs to understand before proceeding further and relating to the private placement. So one by one we will try to understand. So offer of private placement should be made. Offer of private placement should be made to select group of persons. As I told you earlier, okay, to whom it is made? To the select group of persons, not to everyone. So select a group of persons are only entitled to get this particular private placement offer. See, if a company is of the opinion that instead of going to the public at large, if I have a contacts with me who are ready to become the investors in the company, so why I should not issue the securities to my near contacts. So company is having that option available under private placement. So company only can identify to whom the private placement offer letter should be sent. So it is made to the selected group of persons. How this private placement offer should be made? The company should issue private placement offer letter. Like when a company goes for the public offer, company will have to issue prospectus. Similarly, company will have to issue private placement offer letter in case of the private placement. How many? Okay, one time the way offer can be made to how many persons? It should not be made, okay, to more than 200 persons for one class of securities. Okay, so it should not be made for more than 200 persons to one class of securities. It excludes qualified institutional buyers and employees of the company, okay, to whom the securities can be issued under the different schemes, that is ESOP. Okay, so under ESOP the securities can be issued, that is employee stock options. Okay, employees can be given the securities. So it will not be considered as a private placement when you are issuing securities to the qualified institutional buyers or ESOP, because the SEBI is having the different regulation for these matters. So value of such offer per person shall not be an investment size, shall be with an investment size of minimum rupees 20,000. This is important. Okay, so in Sahara Group case, what was happened basically in Sahara Group case, the size of the issue was maximum, okay, 20,000, because as per the income tax rules, okay, the cash can be received if the amount is below 20,000, if it is 19,999. So that was one of the lacuna which was identified by the Sahara Group companies while issuing the securities. Now it is made very much clear, if you want to come up with the private placement offer, okay, you have to, okay, keep the issue size per person of rupees minimum 20,000. So here we have seen few important points. I am just highlighting those points. Okay. No company shall release any public advertisement. So no public advertisement should be released relating to the private placement offer. The name itself says that it is a private placement. How come a company can come up with the you can say kind of advertisement in case of the private placement? So company should not release any kind of private public advertisement or utilize any media to inform public about the offer. Okay, so advertisement should not be made, okay, it should not be informed. So no company utilize any media to inform the public, because it is made to the, it is not made to the general public, it is made to the selected group of person. That is the logic behind this. So public private placement offer shall be approved by the shareholder. Okay, so who should approve this particular private placement offer? Shareholders. And which type of resolution should be passed? Special resolution. Normally there is a process in the company form of business. First, whenever there is a requirement, okay, board of directors, they recommend to the shareholders that we need a funding now, okay, and the private placement can be one of the funding, and then the matter goes to the shareholders for the approval. So shareholders should approve this particular matter, or should approve this issue with special resolution, by passing special resolution, so which will be required, the prerequisite condition. The offeree shall receive the offer by name, and that a complete record shall be kept by the company. So offeree means who? Okay, here offeree means a person to whom the private placement offer is going to be made. Now it is not like a prospectus. In prospectus, a company directly issues the prospectus to the general public. The offer is not made specifically, as we have studied two types of offer in the Contract Act, general offer and specific offer. Here when the prospectus is issued in case of public offer, it is a kind of general offer, but here under the private placement, the offer is made to the selected group of person, and that is the reason it is a specific offer. So it should be made, it should be addressed to the person to whom the offer is to be given. Okay, so his all details should be maintained by the company. The public private placement offer should be the resolution relating to the private placement should be passed by providing all possible information to the shareholder. So explanatory statement is equally important. If explanatory statement will give a fair kind of idea to the shareholders to take the informed decision. So offeree shall receive the offer by name. Unlike prospectus, which is issued at large to the public, so here it should be made to the specific offeree. So shall receive the offer by name, and complete record shall be kept by the company. After receipt of the money, or after issuance of the letters, all these records should be kept by the company from time to time. No person other than a person address shall be allowed to apply. This is very important. If the specific offer is made, okay, other person cannot accept that offer. Similar way, here also, a person to whom the offer is made under private placement offer letter, okay, that person only is allowed to apply for the securities, allowed to subscribe, okay, for the securities. So no person other than person who has address shall be allowed. No person other than person. Okay, so other persons have been debarred. So let's say if an offer is made to A, okay, so for that the B, who is let's say the relative of A or any friend, he may not be in a position to apply for the private placement. Okay, so other persons should not offer, or should not be allowed in that case. Subscription money for private placement offer should be paid either by cash or DD, and not by either by check or DD, and not by cash. This is very important. This was one of the stand which was taken by the Sahara group, saying that they had received money in the cash. Now it is not possible when you are raising funds through private placement offer letter. Now whatever money you are going to receive, you cannot receive that money by cash. It has been debarred. Okay, companies have been debarred from receiving money by cash. So it can be either by check or DD, that is demand draft, and not by cash. Let me just highlight this particular point. This is important point. Not by cash. So companies now cannot take any particular cash for that matter. So money is received, okay, जो भी पैसा मिलेगा, money is received shall be kept in the separate bank account, which should be maintained with the scheduled bank. Okay, so एक separate bank account maintain करना पड़ेगा. So that bank account, all whatever money will be received by the company should be deposited, okay, in this particular separate bank account, which should be maintained only with the scheduled bank, not with any other bank like cooperative banks. The company can't utilize monies received unless allotment is made within 60 days. Okay, so company can't utilize monies received unless allotment is made within 60 days. So allotment कब तक होना चाहिए? Allotment should be made within a period of 60 days. That is the condition. So allotment of securities, whatever monies company has received, whatever funds company has received, okay, after receipt of the funds, company's first task should be to allot the securities as promised under the private placement offer letter within a period of 60 days. 60 days, the timeline is given to the company within which company should issue the securities. And after which, after issuance of securities, allotment of the securities, the return of allotment should be filed with the registrar of companies within a period of 15 days. Okay, within period of 15 days, return of allotment should be filed. Okay, so उसको हम लोग कहेंगे ROC के साथ फाइल करना पड़ेगा, रजिस्टर ऑफ कंपनीज के साथ रिटर्न ऑफ अलॉटमेंट विद इन अ पीरियड ऑफ 15 days. Now it may so happen company is not allotting the securities within a period given, so the repayment of application money in case default is made, okay, it should be repaid again within a period of 15 days. Okay, so that is the a company shall allot its securities, but if the company is not able to allot within a period of 60 days from the date of receipt of the funds, then in that particular case company will have to return the money within a period of 15 days. I can write down over here, within 15 days. Okay, along with that there will be a penalty or the interest rate should be paid, okay, if company fails to repay the money at the rate of 12%, at the rate of 12%. So I can just write down a company fails to repay application money within 15 days after expiry of 60 days. Okay, interest at the rate of 15%, sorry 12% per annum will be levied. Okay, so this much interest can be levied on the company if it fails to repay the application money for not allotting the securities within a period of 60 days. Then company should maintain the complete record of private placement offers, like which particular record, full name, address, permanent account number, ID, class of securities, date of allotment, and everything should be okay properly maintained. No fresh allotment, no fresh allotment, or you can say no fresh offer of invitation shall be made unless the allotment is made for earlier offers. Okay, so company has been debarred from coming up with the new fresh invitation, okay, of under this particular private placement offer if the earlier allotment has not been completed. And the last point we can say about the penalty. So what can be the penalty? Okay, so if company makes offer or accept money in contravention of this particular provision, like in Sahara Group case, okay, its promoters and directors can be held responsible, liable for a penalty which may extend to the amount raised or 2 crores, whichever is lower. Okay, penalty it may extend to the amount raised, it may extend to the amount raised through PP, that is private placement, or rupees 2 crores, or rupees 2 crores, whichever is lower. Okay, so this is a penalty, again very important. So what we have studied over here, if company fails to repay application money, the period you should not forget, the 60 days timeline is given to the company to allot the securities, and if 60 days are expired, then within 15 days, within next 15 days, company will have to return back the money. And if it doesn't do so, okay, then interest at the rate of 12% per annum, interest at the rate of 12% per annum can be levied. No fresher offer of invitation shall be made unless allotment is made for earlier offer. So allotment is very important part, okay, in case of the private placement. Otherwise no fresh offer can be made. Penalty, it may extend to the amount raised through PP, that is private placement, or rupees 2 crores, whichever is lower. So these are the very important points. Just make a note of all these points very quickly. So we started with private placement, section 42. In one line, okay, what you can mention? Private placement means any offer of securities or invitation to subscribe securities to select group of person under section 42. Then we talk about two different one case law, that is Sahara Group, which were these two companies. One was Sahara India Real Estate Corporation Limited, the second one was Sahara Housing Investment Corporation Limited. So they issued optionally fully convertible debenture to the 2.3 crores of the investors India, which was surprising fact. Those companies, okay, raised almost 24,000 crores of rupees, which even Supreme Court asked Sahara Group to repay back. So if we need to understand the important points relating to private placement, it should be made to selected group of persons through private placement offer letter. Should not be made to more than 200 persons. So now you need to understand, if a company is going beyond 200%, then it is very much clear under the explanation of section 42 it is given that then that offer will be considered as the public offer, and all the provisions relating to the public offer will be made applicable to that particular offer. It excludes qualified institutional buyers and employees of the company. The value of such offer should be minimum size of rupees 20,000. No advertisement because it is not made to the public. All these points are important. If the question is asked in the exam, then you should be in a position to write down this answer. This 14th point I have covered in the 15th as well, so it is connected point. Repayment of application money. It cannot be made by cash, scheduled bank, 60 days, return of allotment, and then the last slide we have studied. %, interest rate will be levied for the delayed payment. No fresh allotment can be made, invitation can be made unless the first allotment has been completed. Allotment is important, and there is penalty. So now earlier this provision was not there for all types of securities, but now here we are talking about the securities. We are not talking about only the shares. So this particular private placement offer is applicable to all types of issuance of shares which are recognized under the Companies Act. Okay, so students, we have completed chapter 3 of the Companies Act 2014, which was very important. It was relating to the prospectus, types of prospectus, matters related to the prospectus, liability in case of misstatement, and last but not the least, the part B, that is private placement. So with this, okay, we have completed chapter 3. So in next sessions, in the coming sessions, we are going to start with the very important concept, that is share capital and debentures. So first we'll talk about the share capitals, what types of share capitals are there. Okay, then we will talk about various types of issues under the share capital. Then we'll talk about the debentures as well. So we are going in a sequence, and we will not skip or hide anything. So that's it from my end today. I hope you have understood all these provisions and very important case law which we have discussed. And with this we have completed chapter number 3. So please do watch my earlier videos as well. the prospectus related videos and private placement should be watched together, so that you will understand in a better way how this private placement concept is different from the prospectus or the public offer. So here don't get confused, we are not issuing prospectus, we are issuing private placement offer later and not the prospectus, which is we are issuing to the, we can issue to the selected group of persons. So that's it from my end today. I hope you understood these provisions very well. In the next lecture, we will come up with a very important topic of share capital. Till then, goodbye, and please watch these videos.